Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case that was just heard at the Supreme Court of Canada that dealt with something called public interest standing. Public interest standing allows litigants without a direct interest to bring cases respecting public interest issues. This means that an organization that's not directly impacted by a law can bring a claim on behalf of other unnamed individuals who have been impacted. The charity that I work for, the Canadian Constitution Foundation, has acted as a public interest litigant. We've successfully sued the government as an organization over laws that could have broad social harm. If we couldn't bring those claims, we would have needed to wait until individuals were actually hurt by unjust laws. In the Supreme Court case, which was called the Attorney General of British Columbia and the Council of Canadians with Disabilities, the court was asked to consider what is the test for public interest standing. The CCF intervened in this case, as did about 20 other interveners. Here to discuss the case is the lawyer who represented us, the CCF, in that case, Mark Sheely. And we're also joined by the lawyer for another intervener, Aline Sigurdsson from the BC Civil Liberties Association. Thank you both so much for joining me today. I want to turn to you first, Mark, about what you can add to my description of what the test is for public interest standing and what role public interest litigants play in the justice system.
Well, I think to start, the test ultimately has three major factors that judges must weigh, and it's whether the case actually concerns a serious justiciable issue, whether the proposed plaintiff has a serious, a real stake, you might say, or a genuine interest in the matter. And number three, whether the proposed suit in all the circumstances is a reasonable and effective means of bringing the matter before the court. It's really significant that this public interest standing be available in certain circumstances, because there are many, many cases where individual effective plaintiffs aren't in a realistic position to prosecute their claims. And it's the only viable way, as a practical matter, to hold the government to account and ensure that constitutional rights, are being protected.
Now, Aline, what's your view on the role of public interest litigation and what value it brings to our justice system?
So the law around public interest standing, I think, really illuminates that. The whole reason for a public interest standing as a category, like a way for people to bring litigation, is to make sure that laws that are on the books aren't immune from review. Right. So immune from review would be as if there's just no possible way to challenge them. And sometimes, practically speaking, there's just not an individual who's going to be able to come forward, or who's going to be prosecuted, or who's going to be harmed in a direct enough way, and have the ability to bring litigation. So it's a way for our constitutional framework to have a realistic possibility of holding itself to account. So there's it's part of that kind of fabric of acknowledging that we have a charter, we have a constitutional system that has to be kind of kept in check and always kind of subject to review. So there's that. The other aspect is it really allows for cases that are developed with a systemic view in mind. So systemic in the sense of affecting a group of people rather than just one, or systemic in the sense of having broad effects that aren't, necessarily going to be teased out by the case brought by one person. So it has a role in really ensuring the accountability of our system is robust.
Now, Mark, you laid out what the test is for public interest standing, but at the Supreme Court, what exactly were they considering? Were they considering narrowing that test? Were they considering broadening it? What was that about?
That's interesting you say that. I mean, if you were to listen to the parties, everybody would say they were trying to maintain the test as it is. But I think ultimately the question facing the court was whether to accept the Attorney General of British Columbia's submission to narrow the test, to add a couple of glosses onto the existing test to restrict the availability of the test, whereas everyone else involved in the case, the interveners and the respondent, all wanted to maintain that test.
Now, if the test was narrowed, it would have made it harder for public interest organizations to bring litigation as a public interest organization. When we come back from this commercial break, we're going to talk about some of the underlying details of this specific case, why this case was where we were considering changing the test. Welcome back to Canadian Justice, where we're discussing what exactly is public interest litigation and how can an organization bring a claim on behalf of itself, an organization, instead of individuals. Now, Ellen, this case where the test for public interest standing that was just at the Supreme Court, the background of that case was really interesting, and I think it illuminates some of the challenges that you laid out for individuals bringing litigation in the earlier segment. So can you tell me what that case, the underlying case, was about and why it was being brought by this organization, the Council of Canadians with Disabilities, instead of by individuals who are being hurt by the underlying law being challenged?
Yeah, so the litigation is about laws that have to do with imposing medical treatment on people without their consent in the context of mental health litigation. So it was a challenge to some laws in British Columbia that under certain circumstances could impose involuntary treatment. And on its face, you can imagine the concerns with that because of the requirement for consent of any kind of medical treatment. And so initially the challenge was brought by the organization, the Council for Canadians with Disabilities, and two individuals. As the process
These would have been
along,
individuals who were impacted by that mental health law about involuntary treatment.
Exactly. And those individuals would arguably have had direct standing. So kind of the discussion about public interest standing really would not have been front and center. At some point in the process of litigation, those individuals, for reasons that are not, within my knowledge, had to withdraw from participating in the litigation, had to not be part of the claim. And so the council amended its pleadings to pursue the litigation on its own on the basis of public interest standing. And that's really when the dispute started, with the province challenging the entitlement of this organization to bring the claim.
Now, Mark, is there anything you'd like to add about the background of that case, and why can it be so hard sometimes to find individual applicants who want to participate in litigation like this?
Yeah, well, I think the difficulty finding interested parties can really run the gamut. I mean, in a case like this, one can speculate as to why those two specific individuals left out. And more broadly, if you're facing mental health litigation, who knows what impacts may be had on individuals facing specific crises. More broadly, being a plaintiff in litigation isn't easy. And litigation of this nature isn't for financial payoff. It's to hold the government to account. And there's no big payday at the end of a long, arduous process for the plaintiff involved. So for somebody who has a busy life, they have a job, they have a family, they want time to work out, they read books, to then add in, okay, well, you're going to have the responsibility of making all these litigation decisions, committing to it for what could be 4 or 5 years, maybe longer. You'll be asked all kinds of questions. You'll be exposed to all kinds of scrutiny in public, in the media possibly. It's a lot to ask in the current environment.
Yeah, I know we've brought some litigation as a public interest organization alongside individuals through my work at the Canadian Constitution Foundation. And it takes a lot of courage for people to stand up and say, I'm willing to be named as an applicant or as a plaintiff or as a petitioner, because it attracts attention and it can attract a lot of negative attention. Now, Eileen, I apologize. What's your view of why the government might be trying to make the test for public interest narrower, public interest standing narrower? It seems somewhat self-serving to me, since it, after all, is the government getting sued, and it would obviously be in their best interest to make it harder for them to be sued.
Well, I think that's certainly part of it. The way that we talked about it in court last week was that we think that it's really the government expressing its preference for how this kind of litigation should be addressed. And there are strategic benefits for government in facing litigation brought by an individual rather than an organization that has the connections and resources and the capacity to have the staying power, as Mark's kind of adverted to pursue complex litigation over a period of years. So there is a strategic aspect to it. On the other hand, a government might have, legitimate resource allocation issues that it's worried about, and it thinks, I think based on stereotype, but it believes that there's going to be too much litigation brought if organizations are allowed to kind of bring these things willy-nilly. But that's not been the experience in real life.
Welcome back to Canadian Justice, where we're discussing the role of public interest litigation in the justice system. Now, Ellen, over the years, there have been a number of cases brought to courts by public interest litigants. Maybe we can illuminate what some of those court cases involved, so we have some context of the importance of these types of lawsuits in our justice system. What examples can you give me?
There's quite a few prominent examples. I'll give you just a couple. A recent one was litigation that was brought by the BC Civil Liberties Association and the John Howard Society to challenge the effects of solitary confinement. That litigation was brought by two public interest plaintiffs together, assembled a robust record about the harmful effects of keeping people in solitary, 23 hours a day, and the effect that has on their life, liberty, security of the person, and their equality rights. Other cases include Carter, which was the case about physician-assisted dying, which was brought by a combination of a public interest organization and individuals, and again, had the ability to assemble this robust record and case. The one that I'm most intimately familiar with is the litigation brought by Downtown Eastside sex workers, who are the organization that ultimately changed the test for public interest standing for the better. Of course, they set out to challenge the criminal laws that affect prostitution related activities, but they ended up being on a years-long saga to seek access to justice.
Mark, same question to you. What are some examples? And another thing is our viewers might be familiar with something called an intervention, which is where an organization sort of adds comments at the end of a case to help illuminate an area of law. Why would an intervention not be good enough and in order to make these public interest arguments? So what are some examples, and how is this different from an intervention?
Yeah, so the example I'd like to point to is the Canadian Constitution Foundation's recent successful challenge of an amendment to the Canada Elections Act. It was a tight case, brought very well handled, well articulated, and it was managed in a very reasonable manner to check an obvious overreach of government legislation to restrict the speech rights of all Canadians. That case is a prime example of the system for public interest litigants work. Now, your question about why interventions isn't enough. I think there's two ways to look at this. I mean, number one, when a party intervenes in a case like we aren't in the recent CCD case, you aren't in a position to comment specifically on that case. You're not asked to say who should win this case. You're asked to talk about how this case will impact other cases. And that's a huge distinction. And the second part is intervention limits you to only participate in those cases that already occur. And what we really need is to ensure that the right cases can be brought and our government is not insulated from being challenged.
Now, Eileen, there were a lot of interveners in this particular case at the Supreme Court, this BC Council of Canadians for Disabilities case. There were, I think, 20 interveners. So why do you think this particular case attracted so many interveners, and what types of organizations were they?
There were 4 Attorney General interveners, so they took similar positions to the Attorney General of British Columbia, saying, got to keep a lid on this. The other interveners really took a broad range of perspectives on the importance of the ability to be represented by an organization in litigation. People ranging from the interests of prisoners and their particular effects to Muslim Canadians, people with mental health and other disabilities, and all the way to public interest organizations like the BCCLA and West Coast Leave, who are interested in kind of a broader range of public interests. Really, the perspective was that what the Attorney General of British Columbia is trying to do is solve a problem that doesn't exist, that people of these constituencies and through these type of organizations are well represented in the courts and it's done efficiently and effectively. So changing the test to reduce that was not going to serve justice. It was going to undermine it.
Yeah, Mark, do you want to add anything to that? We've got about 20 seconds.
Yeah, I'll simply say it's a remarkable case where you had 16 private intervener organizations, or public organizations, I should say, but not the government. And from all across the spectrum, left, right, up, down, all kinds of different issues, in unison saying, please, Supreme Court, do not restrict our ability to challenge cases.
We've got to go to commercial, but we will be right back. Welcome back to Canadian Justice, where we're talking about the role of public interest litigation in our justice system. Now, Aline, another argument that I've heard in favor of public interest standing is that it allows organizations to challenge and even strike down a law as unconstitutional before it actually hurts someone. So can you give me an example of that? And can you expand on why that part of the role of public interest litigants might be so important?
Yeah, so public interest standing could assist in that way if you have a law that on its face is going to be harmful, detrimental, unconstitutional towards a group of people. And it could assist in a court seeing that before the harm happens, something should be done. The difficulty with making that kind of claim is that you don't readily have a record for the harms that the law is going to achieve. But when you have public interest standing, what you can do is you can have an organization step in and say, look at what has happened. Let's not let this ever happen again. Solitary confinement is an example. Should we be imposing that kind of a stricture on individuals ever again? Public interest standing could allow you to intercede before further harm happens.
Really excellent point. Now, Mark, one of the government's arguments in favor of, narrowing the accessibility of public interest standing is that they had concerns over what they called litigating hypotheticals. They argued challenges need to be grounded in fact. So how do you respond to that concern from the government?
Well, it's a long-held judicial philosophy that cases should be decided on real facts, and I'm sympathetic to the idea. Where the P goes under the shell a bit for the government is this idea that everything's about hypotheticals, when really what you have in this case and many other cases is very real facts. What you don't have is a plaintiff who's experienced them, but you may have many other witnesses or other individuals or indirect knowledge. For example, a physician may be able to testify instead of an actual affected a person in the mental health system who can give those real world facts. So to me, it's there's they use it as a specter to scare the judiciary into thinking, oh, we really need to narrow this test, or it's going to floodgate the courts with these problem cases.
Aline, do you want to respond to that as well, to that concern the government raised about litigating hypotheticals in this floodgate argument?
Yeah, I think Mark is quite right. The principle of needing adjudicative facts, which are the who, what, why, where, how of the situation, is longstanding, and it sets up the adversarial process, right? Like, what are we fighting about? But the reality of the situation is, when you're talking about is a law unconstitutional, you're not talking about is it about unconstitutional against one person, really. You're talking about what kind of set of problematic effects does it have? And how is that going to play out on the ground in a number of ways? So is it important for me, individual, to tell you my facts as plaintiff, or is it important for me, individual, to give you that evidence as a witness alongside an expert, alongside a government report, and a range of information? So the hypothetical cases and plaintiffless litigation, it's just not a real thing that happens in these kinds of cases.
Now, the case was heard at the Supreme Court. Mark, how long do you think it's going to take to get a result? We've only got about 20 seconds left.
3 to 5 months.
5 months. Okay. Alan, do you have a guess on the timeline here?
Is it Price is Right rules? Like you can't go over? I think that's a good bet. 6 months, maybe.
Okay. All right. Well, I want to thank you both so much for joining me today and for the important work that you both do working with public interest organizations. I really appreciate it.
Thanks for having us.
Thank you.
We've heard today about a recent case that went to the Supreme Court of Canada, a case that my organization, the Canadian Constitution Foundation, intervened in. The case is core to the work we do at the CCF. We've litigated a number of cases as public interest litigants, and we have successfully had unjust laws struck down in that capacity as an organization. If the rule on how organizations can challenge unjust laws is made too restrictive, my organization and many others like us would not be able to do our crucial public interest work. But what do you think? Will the court allow a flexible and liberal approach to public interest standing? And why would the government be arguing to restrict it? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.